thank you to everybody that is here. We appreciate you taking the time out of your day to come watch our webinar and hear what we've got to say. I'll do a quick introduction of myself. I like to get started on time and try to get everybody out of here. The webinars are always available um, after the fact. So if there's any part that anybody misses, they can hopefully go track that down. Um, my name is George Paget. I am an attorney. I'm a partner with Seaver Walker Paget. We are an eminent domain law firm that works with landowners. So that is my background that kind of gives me a bit of authority to chat with folks about things like this, where there's a potential for eminent domain, what you can expect and what you might see. I am going to start now right into a presentation. I'm going to try to move through as much of that information as quickly as I can. So again, we're not having everybody sitting here all afternoon. There is a function to sort of chat and ask questions, Q&A function. Um, if folks use those, I will do my best. I might not be able to come back to it immediately, but I will do my best to get back to that and answer those questions. So feel free to do that if you have things you're looking to understand better or any specific questions you want to ask. So with that, I am going to share uh, my screen here and get rolling. So we're here to talk about the South System 4, the South System Expansion 4. There's a pipeline. We're here to talk about how that pipeline affects landowners in Alabama specifically, although it does have a slightly bigger geographic reach than that. As I mentioned before, I'm with Seaver Walker Paget. That is our firm. If anybody would like to get in touch with me after for additional questions, anything like that, you can see both my direct phone number, which is the 614 number, and my email there. So I'm always available and happy to answer questions or chat with folks if they have additional things that they would like more information on or questions that we didn't get to handle here, because some things are better suited for a less group type of conversation. All right. So, who are we? What are we doing? I outlined briefly. We're an eminent domain law firm. Our firm does eminent domain strictly for landowners. So we are not with the pipeline. We're not with any pipeline. We don't work for any of the folks on the other side of this that do the taking. We have a generally national practice at this point. That is not to say that we're operating all the time in every state, but we have a broad, wide geographic existence here at this point. And we've done quite a bit of this type of work. So we've got a lot of cases under our belt, as you can see, definitely hundreds at this point, could be 1,000 plus easily. So for the meeting today, for the webinar, I'm going to discuss the little bit about the project, although truthfully, that's not what we're all here to talk about. I want to get you a lot more information about eminent domain, and some do's and don'ts and some things to be aware of and things that you should be focused on throughout the process. So I'll spend a lot more time there, but those are kind of the main things that we're going to chat about today. All right. So what is the project? Like I said, this is the South System Expansion 4. You can see that it is in a little bit in Mississippi, and it also crosses almost all of Georgia as well. I think we've only got Alabama, or should only have Alabama landowners here, excuse me. But so you've got 279 miles across 3 states. Some of the most relevant information here is just this is governed by a group called FERC, which is the Federal Energy Regulatory Commission. They are a national governance institution, so that they're at the federal level. They are not at the state level. The process has to this company has to go through the FERC process in order to get the power to use eminent domain. And they are in that process as we speak. So that process is not a particularly expedient one. I imagine that will take them some time to work their way through that, but it has begun. Um, and once they get that FERC approval, if they do, that is when they will technically have their eminent domain authority. And, they have proposed that they would start construction in 2027. So I think, I've seen a lot of these projects. Lots of landowners probably have not, but those timelines are sometimes aspirational. So I don't know for sure that that's exactly what you're going to see happen here, but that's what is out there as far as information right now. So just keep that in mind. There's a eventually there is a time where they will be building this thing, and you've got to have your ducks in a row and got to know what you're doing before that time, obviously. So that's kind of general timelines, what they're looking at from a regulatory perspective, and about all we're going to talk about in the specific project today. Like I said, if there's other things about that specifically that people really would like to talk about, you can let me know in another context, and I'll do what I can to get you some more information. Let's start with the real basics here. So the lowest building block here of everything that we're going to talk about is this idea that eminent domain may be in play here. So I want to describe to you folks what eminent domain really is, and what it looks like. So in a sense, it's a power or an idea. It's not a tangible thing, but what it really means is that the government, in this case, a quasi-governmental agency, the pipeline will be sort of treated as a governmental entity, because our federal government or our state governments are typically not the ones that are installing this type of infrastructure. So in this limited sense, they're going to be treated as quasi-governmental. They have the power to use people's land without those people's voluntary permission. But there's two sides to that coin. They're also, as part of that ability, required to provide landowners with just compensation. And you'll see that here in those first few lines. The tricky part about just compensation is that it is not an exact science how we determine that. There will be differences of opinion. So there will be a little bit of a moving target there, but that is where landowners who do the right things and move through the process the right way are likely to see much better results in terms of what they receive as just compensation than those who do not do those things, or who are in a rush to reach a resolution or resistant to challenging this in any way. What the process would generally look like in a situation like this is that at some point if they have not already, they're going to make offers to landowners. They're going to say, here's the space on your property that we need. Here's what we believe that's worth. Please give it to us. For the people who do not say yes, then you sort of enter into a pre-condemnation negotiation phase, is the best way to put it. Doesn't mean anyone has to negotiate, but that's sort of what you can use that time for. And that is typically where an attorney would get involved into a process like this. Attorneys like our firm, or any other attorney that does this type of work, would review offers for folks. If they felt like there was additional compensation and an additional headway to be made on the easement document as well, then that attorney and that landowner decided to work together, they would enter into that negotiation phase pre-condemnation. Eventually, if that is not a successful process, there would be a condemnation lawsuit, and that's when the eminent domain is actually technically exercised. In most cases on a project like this that spans multiple states and is overseen federally, you're likely to see them file in federal court. That process is a little less landowner friendly than it probably would be in state court. As well as in state court, you're going to be venued in the county in which the property is located. Obviously, in federal court, you could be halfway across the state, depending on where your specific property, whether it would be in one federal court or another within the state. So that process is largely normal litigation, but there are some unique elements to it. I think that goes, we typically think that for these initial webinars, it goes a little bit too far to get into the nitty-gritty of the actual process of what does an eminent domain case look like. We more so just wanted to help folks understand top to bottom, bigger picture. This is what the process, this is how it goes. So let's say you're in court, regardless of where you are, you're going to have ultimately the backstop of a trial. If you're not able to continue to negotiate during the litigation process and reach a resolution, you're going to have a trial at some point. And so one of the big differences and why I said it's a little bit less landowner friendly in federal court is that the federal court does not have a guarantee of a right to a jury trial. You may end up in front of a panel of like appraisers and other experts that might you might be at their mercy rather than at the mercy of a jury of your peers. So some of that will depend on, if anyone even gets there, what that looks like and how it shakes out. But that's generally what the process looks like. They make you an offer. There's opportunities to negotiate. If it's unsuccessful, you're going to end up in court. Once you're in court, you can negotiate again or continue to negotiate, but eventually a trial is going to be your backstop. If there's no way to come together, at all, you're going to be letting someone else decide what your property is worth. So there's obviously times where that makes sense, and then there's a lot of times where it doesn't. But that's way down the road for anybody that might be listening today. But that gives you the general process of eminent domain. So in this kind of situation, what is it that the pipeline company actually wants from you? I think it's important for folks to understand what an easement is, what they're really trying to do, and what that might mean for you and for your property ownership effectively. So as I said, they want an easement, which an easement is a bit different than like selling them your land, which is typically what the average person is familiar with, is the idea that, of course, you can sell property, but what are you actually selling here? And the answer is you're selling less than 100% of the rights to your property. The biggest thing that you are going to always maintain control of when you're talking about an easement is ownership. So you will still own the underlying land that is involved in the easement, and you will have other rights as well, but you will have plenty of limitations. And those limitations can kind of be thought of as like the rights that you're granting to them. So you might be granting them the right to install a pipeline, the right to manage that pipeline, repair it, all the things that they might need to do. Along with that might come, certain things that you can't do in there because it would interfere with what they're doing. So the biggest and easiest examples are you won't be able to build any permanent structures within the easement area, like think houses, garages, even large trees are going to be considered to be permanent structures effectively in this context. Overall, the easement document is what will outline what their rights are and what rights you retain, and any obligations that either side would have to each other as part of the ongoing relationship. Because I think one of the most important things to remember here is that this easement will run with the land virtually forever. So if you sell this property to someone else, they will have to deal with the deal that you made. If you pass this property down to your family members, children, they will have to deal with the deal that you made. So big picture, you're looking at that document as what controlling all of the various ways that you might need to interact with them in the future and outlining what they're allowed to do and what you're allowed to do. So you see this question, will they be allowed to do blank on the easement? And the answer is it depends on how you negotiate that easement and what it says. You could certainly find yourself in a situation where you had granted them basically carte blanche to do whatever they want. Obviously, that's not where you want to be, and hopefully that's not what any of your easements look like. But keep in mind that negotiating that document is important, and making sure that it is as balanced and fair as possible is definitely worth doing. Everybody wants to be paid for something like this, but in a lot of ways, because this easement lasts forever, it's equally, if not more important, to make sure that there's enough attention and the right kind of attention being paid to it. What you are told as part of the process, particularly from right-of-way agents or folks that represent the pipeline, is not always going to be the case. Now, that's not to say that anyone's going to lie to you intentionally, but ultimately this document governs, as I mentioned. So you want to make sure that you're not taking folks at their word for things that you cannot independently confirm also exist within the context of the easement. A handful of things to be aware of and the issues you could run into when you're talking about an easement and what they might present to you or typically will present. Unfettered access. They often want the default position to be that they can do whatever they want on your property in terms of accessing it, driving across it, going wherever they need to go. They're obviously not going to have rights to do very many things in those other places, but a lot of folks, desire to have a clearer picture of how it will be accessed and, know that that's not going to involve all the other portions of their property where they are doing other things. Sometimes they'll fail to include clauses that either restore the ground properly or compensate you for damages that might occur in the future. Usually the easement itself and the initial payment that you might receive would be intended to cover all of the things that might happen during construction, the foreseeable things that we can say we anticipate these happening. But there may be things that happen in the future when they come back for maintenance or for other reasons that you want to make sure that's part of the agreement as well, that you're not going to be left high and dry in that event. There's a lot of liability concerns for landowners with projects like this, which I think is very understandable. So you want to make sure you would at least attempt to, if not definitively address that, to make sure that those obligations are clearly outlined between you and the pipeline. And then, this might seem really simple, but just making sure that you're not signing something unintentionally anyway that says that they might be able to put in two pipelines or more pipelines, or that they might be able to allow third parties, they might be taking in some way the ability to grant third parties access to that space. And that doesn't necessarily mean contractors for them to build their project, but rather another pipeline company to come in and put in an additional pipeline without your permission. So that's just a short list. There's a number of other things that you're going to want to be paying close attention to with the easement, but those are some examples that kind of show some of the big things that you might want to keep in mind. All right, I'm exiting sharing here just to make sure that I don't have any questions or anything like that. It does not look like I do, so I'm going to come back into sharing here. All right. Let's move to the next slide here. So we've talked about the easement. There's a lot of things that folks might have that are specific to them that would go, very much in addition to all the things that I've already talked about. But big picture, you want to make sure that easement document is reflective of a fair and equitable deal. The other side of the coin is, of course, compensation for the ground that they're taking and the impacts to your property as a result of their easement. There's a number of different elements that you're going to want to at least have in mind and be aware of. Certainly the price for the ground that they're using. That's probably the most obvious to everybody. There's also can be crop damages, timber damages, other types of damages that might come into play depending on how the property is used. We found that it's really important to make sure that there's a well-outlined agreement in terms of how they're going to restore the property. But we've also found that no matter how well that's outlined, there's probably going to be folks who are not particularly pleased with that process or who do not feel like that process truly returned their soil to the state it was in prior to the easement. So, considering payments for those damages or remediation that's going to be necessary is another element you might want to, be considering. There can be additional damages that have nothing to do with the soil, like irrigation concerns, field tile, depending on where you are. Compaction is a soil concern, but soil mixing is a soil. But there can be other things to consider as well, some of which kind of relate back to the previous point, some of which would not. But all of those things can be damages, and depending on the situation and the property and the facts of the particular case, all of those could come into play. There's also what we would call residual damages or residue damages, or damages to the remainder. And this is really where the idea that what they're doing affects the rest of your property comes into play. So not everybody in the world is going to see it that way, but I think a lot of landowners and I would assume landowners that attend webinars like these are probably thinking about things like that. If you've got a piece of property that doesn't have a huge pipeline easement across it, it is sort of inherently superior to one that does. So a part of the consideration in the way that someone would look at a case or a situation like this, if they're doing it properly, should be to consider what type of damage an easement like this might do to the value of that property. And that can be as simple as the easement is fairly close to your home and that damages your home. It could be slightly less obvious in the sense that maybe the easement crosses diagonally through the middle of the property and therefore is going to cause problems down the line for that property's usability or potential development even. So residual damages are a big part of this. I will say that I like to call it the haunted house effect. And the reason that I say that is lots of people will have a specific concern, safety or aesthetics or um, soil damage or whatever the case may be. But ultimately, really what we're talking about is if you have two homes in a community and one is considered by everyone to be haunted and one is not, the haunted house is probably going to sell for less if they're both hitting the market and are otherwise similar. That's a little bit of what we have here. You can get bogged down in specific reasons, but sometimes it's easier to say it's obviously inferior, and whatever the reason is, we still need to address it. So that's a way that I look at it that I think is useful for folks. But ultimately, yeah, those residual damages can be a very big part of what we're talking about here. And then in addition to that, depending on the project and the company and what they're doing, there might be other payments and other things that they're offering to try to incentivize people um, to make deals. So ultimately, we got to consider all of that and all those various things and potentially other things in very unique circumstances and make sure that the compensation package is complete for folks. We want to talk a little bit about the right-of-way side of things. None of this is to indicate that these right-of-way folks have any ill intent or are out here trying to take advantage of people, but I think that we do believe that there are some potential pitfalls and some issues that you can run into that are worth bringing to your attention. Um, they will do a lot of things that are intended to obfuscate sort of the bigger picture, entice you to make a deal quickly, those kind of ideas. And so just be a little bit wary about some of these things and consider the bigger picture before you're hopefully not making a snap decision because you see one thing or they told you one thing or whatever the case may be. So sometimes they will say like, well, we've determined fair market value, but we're offering 125 or 150% of that. Like that's great, but let's make sure that what they're saying is fair market value is truly representative to fair market value and that this is a good deal, right? And even if it were a really good deal for the price of the ground, it doesn't mean that it's incorporating damages and other things and all the other elements that need to be considered. Bonus payments are another thing. Don't we try to make sure folks do not lose track of the bigger picture because there's an extra $5,000 if they sign up this month, kind of thing. Timber and crop damages, those are a part of the process, but again, you don't want to get too focused on those and allow that to sort of muddy the bigger picture. A lot of this is frankly just about leverage. It's about they have a lot of leverage. They have a lot of ability to dictate what happens on a certain timeline. But if we want to exercise the leverage that we have, we are able to do that, but we have to approach it from a slightly different perspective, and make sure we're pressing the buttons and pulling the levers that we have to use on our side as well. Be careful of verbal offers. We're always advising anybody if they're going to give you an offer, you can't even consider it real unless you're seeing it in writing. You're really going to want to make sure that you get offers in writing, or else it's really, really, really difficult to hold anyone to anything that you get verbally. They might increase or decrease their offers or do different things and move money around and try to scare you. And, so be aware of that. Ultimately, if you're having any question whether you've got a good deal, you should be consulting with some type of professional For example, an attorney that might be able to give you a better idea based on experience and knowledge. This is a good deal, a bad deal, somewhere in between. Right. So be careful with right-of-way agents and a lot of the initial contacts and try to use them for information without giving them too much information yourself. You don't want to put yourself in a weird or bad position because you thought that that person was genuinely there to help you, when the truth is they're really somebody with a job, who's trying to get you to agree to give the easement to their employer. Or for in any event, the person that is or the company that is signing their checks. Um, whoops, let me go back here. What to do when you receive an offer. This is not going to be an exhaustive list, and we trust folks as a general rule to make decisions as adults about how they're going to handle things, but hopefully this will be a little bit helpful for you. We like, again, things to be in writing. Try to get as much communication as you can in writing. Um, do not allow them to rush you. Once you've got an offer, it's perfectly okay to say, like, I'm going to take some time to review this. I'm going to talk to some people, and then I will get back with you. Whether or not you consult with me, or, I mean, truthfully, you should be consulting with somebody, as it relates to whether this offer is fair, what your options are, what you need to know. And really sitting down at the kitchen table with these guys and negotiating in person is not to your benefit. I mean, if you're going to ask for huge amounts of money and they're going to say yes, that's great, but I can promise you that's not what's going to happen. So you really want to make sure that you're trying to control the narrative and the flow of information to you, with not as much going to them, until you have a really good idea of exactly how you want to approach this. And then you can put, whatever plan you developed, whether that's with assistance or on your own, into play, or into practice, and going from there. Um, what not to do when you're receiving an offer. Some of this will be a bit duplicative, but you don't want to engage immediately in negotiations about value before you know the lay of the land, before you've got a good idea of what you should be looking at and what it could be worth and all those other things. It's just probably not to your benefit to do it that way. Some people want to think ahead and sort of jump the line and hire their own appraiser right away. It's not that this is suicide or anything, but it is not typically going to be to your benefit. It's really important, if you're going to hire an appraiser, that you hire the right appraiser who's got the right experience and skill set to do this type of appraisal, and then also be an expert witness for you if that's what's necessary. So we really just suggest that folks don't find the first appraiser they can, hire that person, and get an opinion of value, because worst case, could hurt you. Best case, it's premature and probably not worth doing at that point. Like I said, you don't owe these people anything. You don't need to sit down with them and be friendly and hash things out at the kitchen table. It's probably not to your benefit. And don't take their promises at face value. As I mentioned earlier, there's a lot of like, it is good to get things in writing. There's a big potential for the right-of-way agent to tell you something verbally. Then the next time you're talking to the company, it's a different right-of-way agent. They don't know anything about that. They don't know what was said or what wasn't said, and they only know what they can, promise you. And so, be wary, as I've said before. Make sure you get those promises in writing if they're important to you. Don't assume they have your best interest at heart. Also, don't assume that they're right just because they're the big company with all the money and perceived power here. There is a lot of leverage that a landowner can exert in these kind of situations to improve their situation and make it a more equitable result. And also, biggest one, do not rush to a decision. That is never going to be the best way to handle it. And that does not mean you have to sit around forever and wait till the end. It just means don't allow them to present you an offer, make you feel rushed immediately, and get you to do something that you didn't really feel comfortable doing or should not have done. All right, frequently asked questions. Do they have the right to survey? Yes. Typically, as soon as they're petitioning for the power of eminent domain, they have the right to survey in order to better develop sort of whether they should have eminent domain. I know that's going to sound strange to some folks, and I think is for those of us that are property rights advocates, it doesn't feel right, but it is true. You can say no physically and technically, but eventually that is a losing battle. We've seen that play out in many, many courts, many, many times. They're going to be granted rights to survey. The sheriff's going to come out and make you sit on your porch while they do it, kind of thing. So just keep that in mind. Um, if you're curious now that an easement is in your life, do you have other easements on your land? That is something you can look at. There are, your county recorder or assessor's office, there's going to be deeds, and you have the ability to understand if you put in the effort and you can know what's on your property. Um, Obviously, this will not be on your property up until this deed or this easement will not be on your property until you either make a deal with them or eventually have it taken from you. So that's not something to worry about in the immediate future, but it will eventually be part of your property record. How do I find out how much land they want, where it will go? There's really no real straightforward answer to this other than they're going to tell you at some point. Like I said, some people might have offers, some may not. If you do, you're going to have a decent idea of what they're trying to do and what they think it's worth. If you don't, they're gonna tell you eventually. That's the simplest way to put it. And often, if you already have easements like pipeline easements and things like that, it probably will not be very far from those. They tend to try to co-locate is probably the word that you would hear used. They try to be close because it really cuts down on what they have to do from an environmental standpoint and whatever, because a lot of that damage is already done to that area due to the previous pipeline. So keep that in mind. Some people wonder, what if I'm never home? Like, how are they going to get this information to me? They will get it to you. They'll figure it out. If they can't catch you, which they want to catch you because they want to sit you down at the table and kind of sweet talk you into making a deal. But if they can't catch you, eventually they'll send something certified mail. They'll make sure that there's a way to get it to you and to be able to demonstrate that they got it to you. If you don't have anything and you're curious, I don't know if you've ever had any contact with them, you have any contact person, I mean, you can always call and say, any idea when I'm going to be receiving my offer. I'd like to understand the situation and what I'm going to be looking at. But I couldn't promise you that that would deliver results. They might just say, we don't know, and we'll let you know when we do. What if it goes through a building? Final question on here. Look, truthfully, they try very hard, I think, to avoid structures and things that are going to be difficult to navigate. They try to put this through open space as much as possible. They will come close to structures, but they are probably not going to put this through your home. If they do, though, whatever is in the way of their easement, they have to buy, is the simplest way to put it. So, they will be or should be making you an offer for anything that is within the easement area that they have proposed. And if they've not, then definitely talk to somebody. Even if they have, talk to somebody and make sure what they're offering you is fair and reasonable. But if they've not, then definitely talk to somebody and make sure that you've got a handle on that and an ability to not, to be compensated for that if that's if that situation does exist. There's obviously other questions, like I've said a couple times, if there are other questions I'm not hitting on here that people have, feel free to let me know. You send me an email or give me a call and we can chat about them. But those are some common ones. Um, how can I afford an attorney is of course a big question when we're talking about anything like this. Like, what am I supposed to do? How do I fight back? What options do I have? I just want to give you a really quick example of how attorney's fees typically work in this kind of situation. Most attorneys are going to work on a contingency fee basis, which means it's not a typical hourly agreement with a retainer up front and money billed along the way. It is more of a results-based fee that is taken from the value added when everything is resolved. So let's say you had a $10,000 offer, you had a $50,000 settlement, $40,000 would be the difference there. Like a typical contingency fee is going to be about a third of that amount. You'd end up, when all was said and done, from the 10 with 37 effectively, and your attorney fee would be the difference. That additional 13,000 would be paid to the firm that you are working with. And there's a lot of reasons why we do this. I think probably the biggest are that it allows us to work with way more landowners. It allows landowners who don't have the means to fund litigation for a long time to be able to still get the benefit of representation. And it allows folks not to have to take on an enormous risk that they're going to pay a bunch of money out to an attorney and then not receive commensurate benefit from that experience. So it really works in our industry for to do it that way. Um, so that gives you an idea. It makes us attorneys more accessible to people, which I think is a very good thing. This is a constitutional issue. You're entitled to just compensation via the U.S. Constitution and typically your state constitution as well. So making sure that you have the right help and the ability to navigate that situation in an intelligent way, I think is very important and worthwhile. So that's how that would look. If there are additional questions, again, folks can feel free to follow up with me. Moving forward, what should you be doing? Well, if you have an offer, you should probably be talking to somebody about it. You can send those over, take a look, be happy to try to give you the best advice that we can. If you're not there yet, you should be considering your attorney options and your plan of attack and trying to make at least a loose plan for how you intend to approach this situation. And that's going to involve identifying your priorities and goals. If it's all about money, that's great. If it's all about easement language, that's great. But you want to make sure you're prepared to have those conversations so you're giving yourself the best opportunity to get your concerns addressed in a meaningful way. Often there is strength in numbers with these situations. Being part of a group can give you additional leverage that you would not have on your own. So we are typically trying to put together groups when we do this for that very reason. So keep that in mind as well. Um, if you have questions, you have offers you want someone to take a look at, I'm happy to do that. You're under no obligation to send me anything or reach out to me ever again. But if you do make the determination you would like to do that, there's my contact information again for you guys. So you've got that. That is largely going to wrap things up for me. So, I don't see any questions, which is great. Feel free to email me or give me a call if you do develop any. Thank you for your time, and hopefully this was helpful, educational for you, and gives you a little bit more confidence that you can manage this situation one way or the other. Oh, okay. Actually, it looks like I did just get a question coming through. All right. If you'd like to type out the question, I'm happy to try to answer that for you before we wrap up. I'll give you a second here to do that before we. Okay, so the question is about temporary workspace. So this isn't something that I mentioned, but often along with their permanent easement space, they will take what we call temporary easement space, which is extra workspace that you get back eventually. You get full ownership back. They will have no rights to that space at the end of the day, but they will have the ability to use it for a certain period of time, typically while they do their project. That is also going to be part of the eminent domain process. Yes, if they need temporary workspace, they will be able to take that as part of the lawsuit, the eventual lawsuit. So it's not like waiting gets you out of having to give any temporary workspace. They're going to get a lot of leeway, a lot of discretion to determine what they need and include that in their process. If you have livestock, which I'm seeing a follow-up question, if you've got livestock, that's actually a really good example of like an easement consideration that might be unique. I had a farmer that I worked with one time, or a rancher, I should say, that had a bunch of animals, and because of the way the pipe was crossing the property and because of the way the property was designed and used, there was just no way during this, couple months where there was going to be significant interference from the pipeline for them to get water to their animals. And we had to negotiate effectively that there would be water brought in and provided to those animals. So if you have to move your livestock, for example, which is I think what the question's getting at, you would have to potentially negotiate for them to install temporary fencing, things like that, to give you a space that is going to be workable, that won't be interfering with what they need to do, that would also keep everyone safe, you, your animals, as well as them, while that process is ongoing. So yeah, that's absolutely part of the equation for certain people, and those are things that, in addition to the real big picture stuff that we talked about, that are going to be part of ultimately, if you're coming to a resolution, hopefully those things are part of that process as well. And there could be a million other things. And part of our job is to work with, if someone's working with me, is to work with them in a way to try to understand all of those concerns, big ones, small ones, and in between, determine which ones we definitely can address, and then address those, to the best of our ability, right? So yeah, and if those are big concerns for folks and you want to talk more about it, you can definitely, like I've said, shoot me an email, give me a call, whatever the case may be, and I'm happy to spend some time getting you some additional peace of mind and explaining a little bit more about how that should work. So thank you, folks. With that, I'm going to wrap up here. I very much appreciate it. And like I said, hopefully this was helpful for folks, and we will, hopefully talk to some of you again here in the future. Thank you.